Thank you all for joining us. I think we'll go ahead and get started. My name's Maria Emanuel. I'm the Associate Director for UNH Innovation, and we're thrilled to have you join us for the academic year 2015-2016 Catalyst Seminar Series. Some of you are familiar faces, some of you are joining us for the first time. We have a theme this year, which is called A Conversation About, and we're going to be inviting New Hampshire businesses to come and talk about needs and technical challenges that they face as they are growing their businesses, and then to partner that with faculty presentations about related research and a chance for crosstalk between the two groups. Today we're going to do something a little bit different. We're kicking our seminar series off on a Wednesday, but we're very fortunate to have Eileen with us from the USPTO, and I'll introduce her in a few minutes. So, for those of you who are new to joining us, we host the seminar series. It's roughly the fourth Thursday of every month, give or take this month, November, December, probably another month or two along the way. But we have a plan. We have a plan. And we will be publishing information about upcoming seminars. Our next one will be on the fourth Thursday. It'll be October 22nd, and it'll be held here, and we'll be announcing information shortly. Our idea is to bring together folks who are interested in questions related to innovation, intellectual property, entrepreneurship, whether it's in their research program. We have a great showing today from UNH, or outside of UNH, and a chance just to get like-minded individuals together to have some conversations and learn some more information. If you have suggestions of things that you'd like us to think about or address, we're always happy for the feedback, and thanks to those who responded to our surveys at the end of last spring, I guess, when we got a lot of valuable information. Some housekeeping items. We have to remind you that you need to be 21 or older to enjoy the beer, but otherwise we can toast you over a bottle of water, and we have some great refreshments to enjoy. Please stay afterwards for a networking period where we can continue our conversations. Ellen. This is Ellen Christo, and I've asked her if she would mention a great event we have upcoming on November 4th.
So I wanted to let everybody know about our UNH Aerospace and Defense Technology Day. This is an event being put on by UNH Innovation in partnership with the New England Council, the New Hampshire High Tech Council, and the Seacoast Aerospace Alliance, and the New Hampshire Aerospace and Defense Export Consortium. So for those of you who are aware, there's a great deal of businesses in New Hampshire that are in the aerospace and defense area. We figure about 300, and then that doesn't really count even the companies that supply and work as suppliers for those industries. So what we're doing is bringing them here to UNH. A little bit different format. Instead of a seminar, this format is going to be a research sandpit, at least the first part of the day, where researchers and faculty will interact with companies. And the idea being is an exchange of ideas and networking time to be able to find people who can solve your problems. The afternoon of the day will be basically field trips to some of UNH's world-class instrumentation and labs so that people can see and feel and touch what's out there as business resources for local and regional businesses here in the area. At the end of the day, we'll have a networking cocktail party, and the hope being that there'll be a whole lot of great connections that come out of the day for both businesses and for faculty. So there's brochures at the back. Please grab one, sign up online. It's a no-cost event, and we hope we see all of you there. Thank you.
How about the invite a buddy, or if you have somebody?
Absolutely. If you know of somebody, either if you're faculty and you know someone who this would be perfect for in terms of faculty, please pass it around to them. If you're a company and you know, might not be applicable for your company, but it would be for someone else's, and they're a friend of yours, please feel free to pass it on.
And if you have any questions about the program or would like to talk more with Ellen, you can do so afterwards. So, to move on to our main event, it's really our pleasure today to have Eileen Lillis here with us from the USPTO to kick off our seminar series. And Eileen started her career as an engineer with the Navy, and then she has since been with the USPTO for 23 years in a number of different positions. I'm going to read this because it will not come off the tip of my tongue, but currently Eileen is a supervisory patent re-examination specialist in the Central Re-examination Unit. And in this capacity, she supervises the review of re-examination and reissue, as well as supplemental examination requests for patents, and we will hear some more about that. Excitingly for us, Eileen is a New England native, so it's really nice to have her up. She's from Massachusetts, earned her BS Mechanical Engineering from what was at the time Southeastern Massachusetts University. Now you said that's UMass Dartmouth. And then her master's in Mechanical Engineering and Engineering Management from the Catholic University of America in DC. So the presentation today will be an overview of intellectual property. We kept it at a more general level. Eileen has invited questions throughout the whole presentation, though, so we can make it more of a dialogue. And some of the things that I think will be of interest are questions about intellectual property and protection, as well as the role of intellectual property in innovation and experiences you may have had with the USPTO or with intellectual property and the role that has in your business. And so we welcome comments and questions during the presentation. So with that, I'd like to turn it over to Eileen, and thank you very much.
My name's Eileen Lillis. I am from Cape Cod, so I'm not really quite as much a New Englander as the rest of you. I grew up on the Cape. I've been at the office, as we said, for 23 years. I've been a supervisor for 16. I have worked I'm a mechanical. I have worked in I worked as an examiner in torque transmitting devices, constant velocity joints, drive shafts, clutch dampers was my specialty. As a supervisor, I have supervised everything from earthworking equipment to semiconductor handling devices, pooper scoopers, article handling. I even did a stint as a senior manager in one of the electrical areas in image processing, where they discovered that a mechanical in the image processing area is not a whole lot of good because they argue about whether like black and white is a color, and I automatically think they are because they're in the Crayola box. Let's see, I've worked in the Patent Training Academy. One of the things I've learned is I really do enjoy teaching. I enjoy lecturing to the patent examiners, trying to get them to understand how important their job is. That is one of the things I think we don't do well enough in the office, is get the examiners to understand what their patents mean to the people on the outside. When I was a junior examiner, I actually got to go on a field trip, which is pretty rare for us. We get to do very few of those as examiners. As again, in 23 years, I've done it once. And we went to a company, and it was a family-owned company, and we're walking down the hall, and the man who was giving us the tour, his grandfather had gotten the first patent that was hanging on the wall of the line of patents, and he said that was pretty much the reason the company started. That this huge factory employed hundreds of people, all because of one patent way back when. They have many since then, but it's hard to try to get the examiners to understand that the paperwork that comes in front of them, there's a face behind that, and that's really what's important. That these patents that we give out make companies, and that without the patents, people can't go to the bank, they can't get a loan. So trying to explain how important intellectual property is. The reason why I like coming out and talking to the public is so that you can very often get our point of view. Sometimes it seems like we're just there to say no. Yeah, you see, okay. And we really aren't. Our job is to be an advocate for the public, to make sure your patent isn't too broad and doesn't cover everything. Instead, our job is to make sure that it covers the right amount so that the public is protected. And I think not everybody recognizes that. I had a long conversation last night at the Open Bench Project in Portland with a bunch of inventors. And we kept going back and forth over again about, really, it's not that bad of a thing to get a rejection. And actually, sadly, had one guy who filed a patent application, and he did it pro se. And I felt really, really bad when I found out that he got a rejection and didn't know that he could amend and let it go because he thought he had one chance. So that was kind of upsetting to me that nobody was, and then I started to think about it, that our office actions that we send out, and many of you have probably seen them, are full of legal jargon. And and they're written for someone who understands patent law. So it's kind of difficult to recognize that we are supposed to help the public, and sometimes we miss the mark completely. But what we're going to start talking about today is just a basic overview of intellectual property. Or maybe we're not. Come on. There we go. I'll hit that button. And if you have any questions, any comments, please feel free. I'd much rather talk to people than talk at people. So last year, in fiscal year 2014, these are the demographics of the office. We currently have about 9,500 examiners. We will be hiring less in fiscal year 2016 than we did this year. There were almost 6,200 patent applications filed. We issued almost 330,000 patents. There are in the trademark area, and again, I work in patents, so my knowledge of trademarks is I have a couple of good friends who work over there, so I have someone to call when I have a question, which is pretty much anything other than it has a TM next to it, and I know what that means. So there are currently I'd say there's probably about 450. They did some hiring this year, trademark attorneys, maybe a little more than that. Last year, in fiscal year 2014, there were just about 340,000 trademark applications filed, and they issued about 206,000 certificates. So many of you understand the concept of trademark, the TM that we see on everything, right? You know what that means. It is it comes from federal and state and common law. And copyrights, it's works of art. And it's not just the Picassos that hang on the wall. It's writings, it's music, things like that. It comes from the US Constitution, Article 1, Section 8, which I think is the coolest part of the Constitution because it gives me my job. It gives Congress the right to issue to, I'm not going to get the whole thing completely right, issue to inventors and writers the ability to prevent other people from making or using their writings or discoveries for a limited period of time. So I think it's the coolest part of the Constitution. Trade secrets, the recipe for Coca-Cola. It's a trade secret. Nobody really knows it. It goes back to common law. And what we're here to talk about mostly is patents, which protects inventions. Basic concepts of trademarks. It allows somebody to identify something easily. It's got that symbol on it, that little R or the TM. It really is something to help you make your decisions. If you see that Nike swoosh, you know it's made by Nike. Okay, I recognize how important it is. It's really interesting when you actually find, there's some places that you can go to. I was at a seminar not too long ago where they had examples of a trademark, a real, from like Nike, and something that wasn't, but had the swoosh on, and the difference is, slight. But it is amazing the ability that the trademark law gives people to keep that stuff from being brought into the country. It's very, very interesting. It encourages owners to provide goods and services of a certain quality. So people they expect something good from somebody who has a trademark. We were talking today about the trademarks here on campus. How you guys have the trademark for the letters UNH, and anything that you want to put UNH on, you can trademark. So Starbucks coffee, of course, I was driving down the highway, saw the green sign, turned around and was able to get over there this morning on my way over from Portland to give myself a cup of coffee. They're very important. We have Marky here, our little trademark guy. Is that clear enough for everybody? When they have the trademark expo in the office, Marky actually walks around. So there's running jokes in the office about Marky. And he's got a room in Madison West. There's actually a room, and it's labeled Marky. I guess that's where they keep the costume. It's like where Marky lives the rest of the year. These are just a couple. Sure. Was there a question?
Well, it was in the news today. Apparently, Hydrox cookies are coming back.
Really? Cool.
They're coming back because someone was able to show that it was telling someone they had abandoned the trademark. And so this company got the USPTO to say that the trademark's been abandoned. So they bought up, re-trademarked it, they're going to reproduce Hydrox cookies.
Wow, it's real. That's cool. I used to like Hydrox cookies. When you know, like trademarks, that people take these things really seriously. Like, you know, we talked earlier about Velcro, and if we've issued every time, once a year, if we've issued patents with the word Velcro in them and without the little mark next to it, you get a personalized letter telling us, reminding us about trademark law, which I always find funny that here in the office, that at the patent office, we do violate trademarks probably without knowing it, but people are very, yeah.
It's your responsibility to properly mark.
Yes, if there is a trademark in a patent application and we recognize it, we will object to it and mark it. There are many, you know, 200,000 of them got issued last year. So there are many of them we don't recognize. But yeah, you know, I have a feeling Kleenex probably would get upset with us also. But yeah, so people are very careful. If there's a trademark, we are supposed to remind the applicant that trademarks need to be marked. So here are just a couple of yours. You even include the little TM with your foot, which made Jeannie, who was supposed to be here with me but couldn't make it, lives in Penn State, or State College, Pennsylvania, and went to Penn State. So that made me, that's the reason I put that one on there, because it made me think of the Penn State mark for her. So.
Why is that a TM instead of an R?
I think it's a choice, right?
No, that's actually
It's different paperwork.
But it's not, but I have a feeling that's probably,
You can
Yeah.
put on a trademark, but if you register it, you have to pay you guys money.
we like money. Money, you know, one of the things about,
New Hampshire people are cheap.
but you have to remember, like, and I always get very defensive when people say to me, well, my federal tax dollars. Your federal tax dollars do not pay my salary. If you don't apply for a patent application, you don't pay my salary.
Clemson also has a foot, which just
Yeah, Penn State does too.
We also prefer frugal.
Yeah. Coming from Cape Cod, I understand I recognize the difference. It's slight.
We have since registered those.
So,
So
okay.
we're working through getting
Yeah, the little R.
on everything.
So, okay. Copyrights. It protects original works and of our authorship, music, dramatic, written things. One of the things I've done just recently, my daughter is a teenager and she's actually still a Girl Scout, which is kind of cool. You can, all the way up through 18, you can be a Girl Scout. And with our teenage group, when our girls run anywhere from 13 all the way up to 17, we did the we have 50 girls, so about 20 of them did the intellectual property badges. And one of the things we did was we talked about copyrights and trademarks, and we talked about why it's important not to download music illegally. With long discussions about that. You know, basically, it's like, you know, would you walk into the grocery store and walk out with a candy bar without paying for it? No, that's stealing. Well, this is the same thing. If you don't pay for your music. So we're doing an awful lot of work in the office with kids, trying to tell them the importance of patents and trademarks and intellectual property so that they understand why this stuff's important. You know, it's not just there for anybody. How many of you have been to Washington? Okay. How many of you went to the Library of Congress? Okay. The rest of you? You should go. It's one of the most beautiful buildings we have. It's really, really cool. Never mind that it's filled with old books, which is still also really cool. But they are the ones who administer the copyright program. And the USPTO actually advises the executive branch on copyright policy. But I do highly recommend, even if you're not interested in copyrights, to go see the Library of Congress. The interesting thing about copyrights is even without registering it, you can use the little C. I had a friend who was an author, and she would write articles for magazines, and she'd put the little C. And I said, well, what do you have to do to copyright that? And she said, I just have to put the C there. And I said, really? I always assumed, you know, it was before I came to the office that you had to like submit it and they had to accept it. And it's pretty much anything's copyrighted if you put the C next to it.
Question.
Mhm.
So if you put a C without registering it, without telling anybody, how does the other person find out is it real or fake?
It's real if you put the C there.
So if you put a C in there,
And if you think about it, the Library of Congress really doesn't have the place to store everything anymore. It used to. You can submit it within a certain amount of time, I think, to confirm your, again, copyright law is not my specialty, but you can submit it over a certain amount of time to like solidify your copyright. But if it has a C, it's copyrighted, is my understanding.
and protected.
And protected.
Copyright is more of a registration.
It's more of a registration. You basically just say that I'm registering it, and you submit a copy. There are some things they keep copies of now when people submit things, but I don't think they keep all of it. You know, it used to be that if you wanted it, you submitted it and they kept it, which is why they had this amazing library of cool old books, but not anymore.
So what's the difference between registration and submission?
Not much. One, you actually submit a copy, and one, you just say that I've just registered it. It just exists.
There's some things that the the Library of Congress might say this doesn't actually count as a copyright, so it doesn't fit the definition, and so then you won't get the registration. But copyrights, once you create something and reduce it to tangible form, your copyrights are in place.
Right.
And then
And they're good for something like, what is it? It's the life, yeah. So, and there's the entire concept of whether software is copyrighted or patented. And if you think about it, if you want your rights, you know, for software, 70 years after the life of after you're dead, that could probably be a good thing if you've, you know, written a really good program. So it's good for a very long time.
from
So.
our perspective at the university, we really encourage folks to put the copyright notice, because then everybody knows it's not in the public domain, and it's a way of identifying ownership. So it always gives, it's a branding opportunity to say, you know, this is created from the University of New Hampshire by such and such department, and it helps to keep your name associated with it.
Do they copyright like doctoral dissertations and things like that? You recommend that?
There are copyrights for those, and our IP policy talks about ownership of those. When you write your journal articles and submit them, you have to enter into an agreement with the publisher of the journal, because it's all about the copyrights, and you need to grant them the right to reproduce and to distribute your work if you have it originally when you submit your article.
Okay, I've just learned something. That's cool. Again, copyright protection is automatic. A work is created when it's fixed with a copyright for the first time. So the very first time you put the C next to it. And the really irritating thing about, like, you know, Word is that it automatically puts a C in between two parentheses into the copyright symbol. Let's see. And again, no official registration is required. More information is at copyright.gov. Trade secrets, which are just that, secrets. It's the Coca-Cola recipe. Stuff you don't want anybody else to know. Oh, it is the Coca-Cola recipe. It used to not be the Coke bottle there, so they must have listened to me the last time I gave this presentation, and it wasn't the Coke bottle, it was something else, and I said the Coke bottle. So they've changed my presentation on me, and I didn't know it. It's economic value that you don't want to share with anybody. If you were to patent the Coke recipe, then it becomes public, and after the term of the patent, anybody can use it. So it's been much better for them to keep it secret. When I lecture to examiners, I talk about the Krabby Patty recipe and what Mr. Krab has done. For those of you who have teenagers or kids who watch SpongeBob, and your students probably know this, he keeps his recipe in a bottle, in a locked safe, in his office. Okay? So it's literally, you know, that's what you do with a trade secret so that nobody else can figure it out. You know, now if you come up with something on your own that's just like it, that's different, but you probably have to go through a lot of proof to show Coca-Cola that you did it yourself without reverse engineering it. It can be pretty much anything. And that's what's kind of cool about it. But it's kept secret. It's kept in that bottle, in a safe, in your office, hidden. It's common law. It goes all the way back to the 1800s. There are some sort of state secret laws in every state. One of the things I've always thought was really cool about how serious trade secrets are kept. A couple of years ago, there was a guy who either stole the Coke recipe and went to Pepsi, or stole the Pepsi recipe and went to Coke, and the other company turned him in. You know, that's how serious these people take their trade secrets. So there is a Uniform Trade Secrets Act, but there's really no federal law for it. It is each individual state. Oh, there you go. Google, and I think that's the wrong symbol too. That hasn't been updated. I've talked about this. But other things that get trade secrets are customer lists, which is kind of cool. You don't want everybody else, you don't want your competitors to know who your customers are. That's a very important thing. Formulas, algorithms, all of those things. You know, how Google searches is really a secret. It comes up with all the answers and it puts all the people who pay at the top. I know that, but still, how it does it, I have no idea. It's kind of like how you make sausage. I really don't want to know. And there's no set term. You know, Coca-Cola's been around for what seems like forever. They've had their recipe. They've changed it a couple of times. They've made mistakes with it, like New Coke, and went back. So how they would lose a trade secret, not, you know, posting it on the wall for everybody to see, you know, that type of thing. Authorized disclosure. Again, somebody stole the recipe for Coke or Pepsi and brought it to their competitor. That's not an authorized disclosure. You could reverse engineer Coke. I'm not sure how. I'm sure people have tried. But those are ways that can happen. And again, you could independently do it yourself. So, a patent. Oh, sure.
Is there anything to stop someone who independently developed it from using this equipment?
No, I don't think so. I really, you know, if you independently developed something.
Is there any way to declare something a trade secret so that if another company tries to probe to get it through nefarious means, could you then take them to court? Does the Uniform Trade Secret Act?
You may have to ask the attorneys that question. My understanding is that you know, if you try to keep it secret, you know, you don't put it in a poster and hang it on your wall, and someone tries to come in and steal it from you out of your locked safe in your office or that type of thing, that, you know.
I wish we could do that with our online identities.
Yeah.
And our own personal information trade secrets. Okay,
Yeah.
thanks.
So if somebody else files a trade secret.
You don't file them.
And they develop it independently of you, and they file a patent on it. Then they come to you and say, hey, you must be violating our patent.
You know, but you have proof that you were doing it before, right? So but say for example we reverse engineer the Coca-Cola recipe, and we managed to somehow make it just right, okay? And it tastes, and we patent it. Coca-Cola, and we went to Coke and said, hey, look, you're violating our patent. I would assume, and I'm going to look at the attorneys in the room over on this side and and think about this. I would assume Coca-Cola would be able to come back and say, we have been making this for decades, and, you know, thumb their nose at us.
I guess the question comes up, what happens with first to file now? Because they just changed the rules about the patent.
Right, it's first to file versus first to invent. That's why we tell people we recommend that people file as soon as possible versus, that does. But again, if it was a trade secret and you had been doing it for a long enough period of time, I think you could probably not have to pay royalties. You may have to go to court to prove it, but I would think we got an attorney who can answer.
Well, in your hypothetical, the formula that you patented later on wouldn't be new because Coca-Cola.
But it would not have been published. There would be no published document, right? So for something to be a 102 or something to be prior art, it has to be published. I have to have a copy, something of it. So so it's the concept of, you know, yes, I can't patent gravity.
Use
You know.
for sale. Certainly sold enough of that.
Yeah.
But it puts you in an awkward position in
Yeah.
your code.
It puts you in a really
to
awkward.
admitting your trade secret. So they could simply ignore you
Yeah.
and not
But if you go-
acknowledge that
but-
it's
right.
the same unless the
But if you
person
come
proves
after
they
them
got it
and,
from the code.
but if you come after me as the, you know,
Yeah.
if I come
Code
after
chases
Coco.
them down. Code
Oh, no,
says
even,
that
but,
that's the formula,
but
that's
even
it.
the other way. And the other question is, how do you even know if it is the same formula? You know, it could be completely different, but I end up with the same flavor somehow. I'm using different ingredients and,
Right, how do you deal with that situation? You have the same output, same result, but your means of finding.
way above, as my friends would say, way above my pay grade. I have no
When
idea.
the re-examination people are here, some of us think that these days you go to the PPAB and they revert to
Oh, but now that's different than me. An IPR is very different than a re-exam. An IPR, well, yeah, that's really what's happening. But I can talk about that, but I'm not going to do it on camera. So, as I was saying to some, sure.
If Coke has a formula written on a piece of paper in their box,
Hmm.
is that considered publication?
Pardon?
Is that considered?
No, it has to be made public. But yeah, you do have the for sale, but the question is, it's not, the recipe's not for sale, the recipe's not known. So if I was Coke and, you know, we've patented this recipe and I was Coke and you came to me and said you're infringing my patent, I would say prove it. Because you don't know what's in my recipe. I think that would be really the best way to go because,
And if Coke chased them down, Coke would admit that
Right.
that was their formula,
Yeah.
which would invalidate their own trade secret because then they're saying
Exactly.
this is really the formula.
yeah,
So the best, it's like the prisoner's dilemma.
Yeah.
The best thing for Coke to do is nothing.
exactly.
Sounds
Because
crazy,
that's
except for
protecting
you should replace Coke with Google. Pretty much every IPR you read from Google.
Yeah. So, but yeah, I'll talk IPRs, but I'm not going to do it on a video camera. Sorry. I have my own opinions, and if I say them too many times, somebody's going to actually hear them, and I'm going to get in trouble. So, a patent is the right to exclude others for a period of time from making or using or offering for sale or importing, which is really kind of an important thing that's happening an awful lot now, your claimed invention. And the key word there, which I wish was the one that was highlighted, is claimed. Because it's your claimed invention and not necessarily your invention. So it's always very important for people to understand that your claims are what's important and not necessarily what you invented. What you invented and what you claimed hopefully are the same thing, but sometimes what you think you get coverage for is not necessarily what you have coverage for. It is a limited term. It's 20 years from earliest filing date. It is not an international thing. Our patents are not good anywhere else in the world. Although they're highly respected, you still have to go to Europe to get a European patent. You still have to go to England. And no matter what they say, they are not the patent office. Although when you get their like office actions, they say the patent office on the top. Again, the government grants the legal rights in exchange for the disclosure of the invention. So our job is to protect the invention, to encourage inventions, to promote commercialization of an application, and to accelerate the commercialization in the whole society worldwide. The office works really hard with other countries to help harmonize our systems, to make it so it's easier for foreigners to work with our office and for our patent holders to get patents in other places. We have an awful lot of places that we work with that they're working on doing joint searching of applications, which would give you the insight of patent examiners from both here in the States and from foreign countries. We're working, as you know, we've gotten for those of you who know, we have the CPC now, which we're using instead of the US patent system, which has The Europeans have classified all of our stuff and all of their stuff and all the foreign stuff they can get their hands on into one system, which makes it a better search program for us, even though those of us who are old still, like the class I worked in as an examiner doesn't exist anymore. It's in like 4 places. So I'm devastated that I can't say I worked in such and such a class anymore. One of the things, as I mentioned, is commercialization. It's really important that people who have patents can take them out. And that 7-digit number means something to people, that they recognize the importance of that. Okay, here are a couple of your patents. And I'm going to like see if I can make sure I got the name. We have Dr. Ryan's patent and Dr. Short's patent. Here. There you go. And the reason I picked these two was I could pronounce the titles. I did say earlier I'm a mechanical. So I'm a mechanical. I have no bones about it. My best friend's a chemical. I am married to an electrical. By the way, in our house, nothing works. He's reading the directions or I've taken it apart. So just a funny story. My daughter, a couple of years ago, built a windmill, a Lego windmill for a science fair project. And it had a gearbox in it. And the thing would work intermittently. She got the whole thing working and it would work and then it would stop working. And finally I looked at it and the gearbox was broken. So I took the gearbox apart, never thought anything of it. I took the gearbox apart and put it back together, fixed it, put it back together again and put it in and it worked. Until some kid knocked it off the table at school and the thing went into all the Legos that it had come out of or been made of. And she still tells the story of my mommy took apart the gearbox and made it work. So again, I take everything apart in the house. So if you think about the number of patents that go into things, it's pretty amazing. Most people, when they get a new cell phone, open it up because they're excited about the new cell phone. We got my daughter an iPhone not too long ago, and I actually took a moment and looked at all the patents listed on the box. It's pretty darn amazing. It's a lot of ink that goes into listing all those patents on the outside of the box. So, but on here, you have trademarks. You have the Apple. You have all the apps. You have the iPhone. You have the software, which is also trademarked. The Safari is trademarked. You've got all of the patents. You've got the semiconductors, the touchscreen, the battery, the antenna, the speakers, all the stuff on the inside that if I were to take it apart would never go back in again. I've done that too. It doesn't all go back in. Somebody said there's like magic springs that like make it like expand. You have the copyrights, which are the software code. That's all copyrighted. The instruction manual. The ringtones are copyrighted. Even though some of the ringtones I think are trademarked, if I'm not mistaken. Bless you. You know, and there could be trade secrets in there. Again, when you take it apart and you try to put it all back together again, there's a trade secret in there to do that because I couldn't. Many of the designs, there are design patents involved in lots of this. The shape of it, the look of it, that's all a design patent. You know, design patents are lots and lots of things. It is pretty amazing what people get design patents on, and they get utilities. I like to talk to examiners about, you know, think about it, you know, the new Corvette. The body parts of the new Corvette have both utility patents, but they also have design patents. So you can get get 2 different kind of protections on the same thing. So, all right, any other questions? I said this was quick an overview, so any other questions or comments? Yes?
That's re-examination.
Oh, okay, re-exam. So what do I do? The area that I work in is re-exam. We look at patents that the validity has been brought into question. So somebody has a patent on, let's see, what one can I talk about that would be interesting? The BlackBerry rim ones that were around just recently, the BlackBerry phones. They had a boatload of patents. And there were a bunch of them that other people said really shouldn't be patented. And they went out and they found other prior art, and they submitted it to the office. And we make determinations on whether those claims whether a reasonable examiner at the time of the examination would have found the subject matter important to the patentability of those claims, and we determine whether or not, give them a chance to amend. But it is all issued patents. One of the nice things about working in the CRU is that our examiners recognize the importance of what they do. They see that the cases that they're working on are in court. We get an awful lot of things where, there's a district court case going on at the same time as our stuff. Because when they're in court, they very often will file a re-exam in the same thing to try to invalidate the patent. So that is what we do. There are about 100 examiners. We're all senior examiners. We've worked in the office a very long time. Unlike in the technology centers where you can be you're very specific, you work in the same area. We have 19 mechanical examiners, 18, one just retired. We lost Jimmy, which was really devastating because he was just brilliant. But he moved back to Alabama, and he's going to go spend time with his grandkids. So we have 19, and my examiners will do anything out of technology centers 36 or 3700. That's not business methods. And actually, we do some business methods also. We have the electrical area, which will do any of the electrical technologies. And we have the chemical area that does anything out of 16 or 1700. So that is what we do. We've started also working on, now we do all the reissues in the entire office, all the new reissues coming in. We have taken like 90% of the reissues that were being done in the core, and we've taken them over, which is a really good thing because there's something called recapture and some of the other kind of crazy things that the regular examiners don't necessarily understand. And we dealt with it a lot in re-exams, so we've taken over all of those. We also do supplemental examination requests, bless you, where there's almost about 150 of them filed. They've started about 2 years ago, where a patent owner can come in and say, yeah, I've got this patent, but I think there's a problem with the claims. I found this piece of art. Can you look at it and compare it to the claims? And we give them a chance to fix their patent, and they also get immunity from somebody saying, you knew about that ahead of time, so your patent should be invalidated for that. We work on those also. But again, we're experts in different technologies. And
what percentage get overturned or have to be amended?
Amended, probably 60. Very often, lots of the stuff we see coming in are web pages, old magazines, things the examiners in the core would never have found. You Google search something and you're just like, I had no idea how they found that. So, but if you're trying, to take somebody to court for going against, using your patent, they're going to try to defend themselves, and it's amazing what they can find. So we have a lot of that. Very seldom is it a patent. Well, maybe 50% of the time it's a US patent. But it's very often in a place that you would think, really? Why is that there? And in a lot of the mechanical areas, text searching isn't an awful lot of help. I'm looking for the brake on the left-hand side of a gear in a fishing reel. I can't text search that. If I'm going to search brake and clutch in a fishing reel, I'm going to get all of them. I got to go through each one and look at them. So it's that type of thing that, they're going to find it. You have to remember the patent examiners have a limited amount of time to do their job, and these guys probably don't. So you have 2 questions. Whoa, yeah, yikes. What? Let's start here and then we'll do.
So I have 2 questions, one of which will all turn the camera off. The first is, can you give us a tip on what are good practices in terms of prosecuting? So, there are ways that you can go about it that tend to be more advantageous than others. Can you give us the sort of insider's view on what the Patent Office likes to see, ways that are, really valued from your perspective when we come and approach you about doing this?
So one of the things I think is really advantageous, I have the best way to say this, not to be sneaky. Really, you get people, you know, I've heard that there are companies that tell people to tell their attorneys to never talk about what their invention does. Talk about the prior art all you want, but never talk about my stuff. They don't want to make an estoppel in the case, but if there's no discussion of the invention, you know, it's important, and we have a huge, you guys can talk more about this too, we have a huge thing going on now for quality. Not that we haven't always worked for quality, we're just trying to work really hard to work with the outside to get quality applications, because quality applications, quality prosecution gets you quality patents. Okay, if you end up in court, the first thing that these guys do is print absolutely everything they can get their hands on that's related to the patents, right? Yes? Yeah? Right, so it's literally, it's a huge deal. And if the file wrapper is not good, you know, what we look at when we get a patent re-exam, we get a request, we read the request and go, ooh, cool, this is really good. They've got a great piece of art, look at this. And then we go back and we look at the prosecution history and we think, hey, look, right here, the guy argued this, the examiner agreed with it. The request is out the door because the prosecution is clear and detailed. You know, we don't want you to give away everything. We don't want you to claim every nut and bolt. That's not helpful. You know, we have kind of a food pyramid type thing that we talk about very often. And the very top things are too narrow. You claim every nut and bolt and everything you possibly have. Well, I'm not going to find that, but if I change the bolt to a screw, I'm not going to infringe your patent. But you also have the bottom part of it where it's too broad. And you have way too much protection, and that's not helping anybody, and it's clearly not helping the public. So you have the middle part, which is the claimed invention, and that's where you want to be. And you don't want to claim stuff that's not yours, that you don't have a right to. So that's one of the things that are important is, I think, a clear file wrapper is really the best way to go. And not to be, recognize the examiner has a job to do, and I find it immensely frustrating over and over again when people come in and want to be confrontational, because, I've walked out of interviews. I will walk out of interviews again. I will not have you call my examiners names. So.
If you, so working into the other side.
Pardon?
So working into the other side with this re-examination process. If you had published what amounts to now prior art, and then somebody else gets a patent on the same invention where most, if not all, the claims have already been expressed in prior art, does that amount to an alternative to the legal challenge to request a re-examination with the presentation of this prior art that was probably listed by the examiner?
If somebody has a patent and you find prior art, there's a process to go. You actually submit the art to us with a request explaining why there is a substantial new question of patentability on the claims. And it doesn't have to be all the claims, it can be some other claims. That's what a re-exam request is. Merely because somebody files, we have an issued patent and somebody sends in art with respect to the issued patent, that doesn't automatically generate a re-exam. There's a whole series of cases floating around right now in the, we've got like 4 re-exams and there's a bunch of applications, and there's a temperature, and there's a temperature range, and it's like something like 500 degrees or something, so it's not like, normal regular temperature. And it's a huge problem because that limitation's in most of the claims. But that's not necessarily why it was allowed. And these people are having fits because this limitation's in the claim. Well, they don't get that, they don't have the other stuff. So that's the kind of what we deal with.
Can I follow up on the flip side?
Sure.
I think the other part of this question was, is that an avenue that someone like an academic inventor could go without having to hire lawyers and pay all that stuff? Can they go directly to the patent office to get the patent re-examined and invalidated?
A re-exam costs a lot of money. And recently, after the AIA and the fee structure went up immensely, we actually tried to charge what it costs to re-exam patents. It went up tremendously. And one of the arguments has been that it really has knocked out universities from being able to argue about patents. I would not do it as an independent inventor to go against a patent in a re-exam. Writing a re-exam request. And the problem with EP re-exams is that you submit your request in your prior art. And if we order the case, which means we say, yes, we think there is an issue, and if the patent owner makes a comment with respect to that order, then you have a chance to respond. If the patent owner doesn't, and we then issue an office action, you're locked out. You can't say anything else in the rest of the prosecution. So really the best thing kind of for you to do is to follow the published patent applications when they come out and look at the patent applications that are being published. We publish them every Thursday. And look in your area, and if you see things that you're like, geez, this has been around since Adam was a boy, and I've got books that teach this, you can submit that within 2 months of the publication date to the office as part of a protest. And that's a much better way to do that.
Isn't post-grant review a little easier way to get at that? Because that's not a re-exam, it's really saying.
Well, the problem with post-grant review is then you're also you're going to the board. And again, I would not do that without a very powerful legal team behind me, because there's the entire issue that you're going to the board. The board's making a determination on whether to institute, whether they think there's an issue with the claims or not over the prior art. And the back and forth in those cases is just a mess. I would never contemplate doing that without an attorney. So.
I'd like to go back a little bit to trademarks and trade secrets a little bit. Say I had a trade secret process for cleaning something, difficult to clean, and my competitor came up with a patented process to clean something. He says, "Oh, your stuff is clean. It must be using my patent." What right does he have to look at my trade secret because he claims I'm infringing?
I don't think he has any right. I think if I was you, we'd be back to the whole Coke argument of I'd have to say prove it.
So he'd have to go to court.
He'd have to go to court, and lots of things happen in court under secrecy order. So you could,
So I would be forced then to reveal my trade secret.
But you could do it. No, but you would do it You would do it, I would assume, under the guise of secrecy order, and it would never be made public.
So some judge or some referee would review it.
Right. That's really, but I would go to them, and my first argument would be prove it. And if he did figure it out, the exact same method, the exact same combination, but I would definitely say prove it.
How many examiners examine the application?
The very first time, if it is a primary examiner, 1. If it is a junior examiner, you have the junior examiner who reports either to a primary or a supervisor. We have a kind of a stepped grade system. So when you first start off, you have a lot more supervision. As you work your way up, you hit a point that you get, even before you're a primary examiner, that you're working mostly independently, but the allowance of the patent is reviewed by the supervisor. You would go, once you've been in the office, probably 4 or 5 years, you go through something called a program, where over a 2-year period we review a sampling of your cases to make a determination on whether you understand the rules and regulation well enough to grant patents without supervisory review. The one thing that we do encourage a lot with examiners is for examiners to go out and ask questions. If they've got something and they don't know what it is, and they've never seen anything like it before, and they've looked for it and they can't figure out what to do, we really highly recommend that they go and ask somebody else. When I had an arts unit years and years ago, one of the things I instituted was for my senior examiners to be able to sit down once a week, and I said, I don't care if you have coffee or not, talk about your cases. You know, and at first they were all hemming and hawing about it, and after a couple of months, it would happen over and over and over again, that they would sit there and you would have the senior examiners who were used to not talking to anybody but come up and say, I've got this, I can't find it anywhere, but it just seems like it's got to be someplace, and talk to other people about it. And that's really an important thing that we used to have something, being old, we used to have something called the shoes, where we kept the patents in big rooms, like this would be a small room for shoe cases, filled with stacks of files with drawers in them, and we called them shoes, because supposedly Thomas Jefferson kept the issued patents rolled up in shoe boxes. So the boxes that we kept patents in were shoes. And one of the things that would happen is you'd be in the shoe cases, and you couldn't find something, and you'd ask somebody else in the shoe case. Well, now that we do it all on the computers, we don't have that now. So we try really hard to get people to encourage them to talk to others. But technically, really, it's only one person who looks at the case the first time. When it comes to re-exam, it's a panel of 3 that makes every decision.
When I've worked with patent attorneys, they usually want you to put in the broadest possible claim and then a whole subsequent claims.
Mm-hmm.
Can you explain the process that would happen? Let's say someone challenged the claims and you lose the broadest claim.
Mm-hmm.
What then happens after that?
Well, what happens, okay, so you have your patent, and a re-exam is filed, and the prior art's dead on for the independent claim. Your options there, you could amend the independent claim. You could cancel it, make new ones. But if you cancel it, when you read a dependent claim, how I always train people to do it is, a claim is the world's worst written sentence. If those of you who know patents, it has to end, it has to have a period. And we do our best to make it a very, really long sentence. I had an examiner once whose wife was a book editor, and he had a 22-page claim. Now, he was dealing with a semiconductor handling device, so it wasn't that outrageous. And I think she's still trying to fix it. We use semicolons and commas in ways that English teachers cringe at. So, and then we have dependent claims that are part of the independent claim, but they're different, and it's really hard to explain to people. What I've always told people to do is turn that period into a comma and delete the same words from the beginning for the next claim and keep reading. But when you get to re-exam, if we've canceled claim 1 because it's been invalidated, what do? It's still there because it's canceled as itself, but it's still part of claim 2. So when we issue a re-exam certificate, the canceled claims are actually still physically there in brackets, so that you can.
The more restrictive claim.
You could go with just the more restrictive claim. Yes.
I'm gonna stop us here.
Sure.
You were after 5:30, but I think you were able to stay
I-
with us
oh,
for
yeah.
a while. So let's move it on to have some beverages, have some food, have some more conversation, and if you could join me in thanking Eileen for a great start.